Thank you very much for this introduction. All right. And I would also like to thank you for your kind invitation to give this presentation. The topic of my presentation is more traditional and classic. For some member states, these issues are already solved, but for Cyprus, law is still a quite debatable issue. This presentation derives from an article which is forthcoming in European Company Case Law Journal, a new law journal published by Nomos. First of all, a few information about Cyprus company law, very briefly, obviously. Cyprus companies law derives from English Companies Act of 1948 due to the colonial past of Cyprus. But Cyprus legislature has not followed all recent developments having taken place in UK company law. Cyprus company law is rather an old-style UK company law, following still the 1948 UK Companies Act. For example, the director duties are not yet codified. They are based on common law and law of equity. The derivative action is not yet codified. The winding up is based on the structure of 1948 UK Companies Act. Additionally, the harmonization of company law is something that Cyprus had to follow as an EU member state. Some recent trends come from Irish company law. Recently, Cyprus legislature followed some developments taking place in Irish company law, such as the pre-insolvency proceedings of examinership. Cyprus courts refer very often to English common law and the law of equity. Cyprus interpret quite often the provisions of Cyprus companies law on the basis of English cases. The Memorandum of Association should mention include the company's objects according to Article 4, Paragraph 1b. This mandatory inclusion of corporate objects contributes to the protection of shareholders and creditors. The ultra-vires doctrine per common law, the company's objects, which should be included in the Memorandum of Association, set the powers to execute the actions for which the company was constituted, and any action beyond the specific objects stated in the Memorandum of Association is considered to exceed the powers of the company, to be ultra-vires, and as a matter of fact, to be ab initio null and void. Under common law, the ultra-vires doctrine dictates that the company's objects, including the Memorandum of Association, delimitate the contractual capacities of the company, and if a company signs a contract which lies outside the company's objectives, the company acts ultra-vires and the contract is from the outset null and void, according also to the English case law applicable to Cyprus. Now, the issue of validity of contracts, cite ultra-vires, is now dealt with by virtue of harmonization of the ex-First Company Law Directive. Now, this directive is incorporated into the General Company Law Directive. And we have Article 33A of Cyprus Companies Law, which provides regarding the ultra-vires transactions that the company is bound against third parties by acts or transactions of its officers, even if such acts or transactions do not fall within the objects of the company, unless such acts or transactions are outside the powers that the law grants or allows to be granted to such officers. The ultra-vires doctrine, according to this provision, Article 33A, Paragraph 1, is abolished. A transaction which under the previously applicable common law regime was considered technically to be ultra-vires and thus void, is considered to be valid now under Article 33A. Furthermore, the constructive notice of third parties having transacted with the company is abolished as regards the publication of the Memorandum of Association and the Articles of Association of the company. But this abolition of the ultra-vires doctrine must follow these two specific conditions. The first one is that the third party did not know that the acts or the transactions were outside the corporate objects. And the second is that such acts or transactions may not take place exceeding the powers of the company. Our Article 33A covers only the company's officers. We mean the director, the managing director, and the secretary. So the employees of the company performing some administrative duties, they are not covered. This category of person is covered by the interim management rule. We will talk about this afterwards. The phrase third party knew or was not possible, given the circumstances, to ignore, is interpreted still according to the common law provision. This person must transact in good faith, and good faith, according to English case law, is a subjective criterion, and the person acts in good faith if it acts genuinely and honestly under the circumstances of each case. Article 33A, 1, abolished the ultra-vires doctrine regarding the external dimension. With regard to the internal dimension, the ultra-vires doctrine continues to apply to Cyprus company law. This means, with regard to external dimension, this means that third parties acting in good faith are being protected. But with regard to the internal dimension, this means that shareholders and creditors may ask for protection. There are certain ways that the ultra-vires doctrine could provide protection to such shareholders and creditors regarding the internal dimension. There are various examples. The shareholders could apply for an injunction. The shareholders could also apply for the dissolution of the company on the grounds that the object cannot be achieved anymore. Additionally, the shareholders, the general meeting of shareholders, may adopt an ordinary resolution which could avoid this transaction and ask for compensation. Furthermore, the secured creditors could ask for an injunction relief, and also we have the power of the court to relieve the officer after a petition by the shareholders. Now, we also have the internal management rule of English company law. The rule of internal management, or otherwise the Royal British Bank versus Terkant rule, the interim management rule or internal management rule, as it's called in bibliography, applies with respect to the commitment of the company towards third parties who considered in good faith that the internal regulations of the company have been observed. The interim management rule, adopted by the famous English case Royal British Bank versus Terkant, allows a person dealing with a company to assume, in the absence of any circumstances to be investigated, that there has been full compliance with all internal management and process, that everything is fine from an internal management point of view. Cyprus case law has adopted quite strictly the internal management rule until 2004. There are various decisions here. I'm citing an extract translated in English, which cites from UK authorities the internal management rule. But since 2004, that Cyprus became a member of the European Union, we have Article 33A2, which regulates the issue of limitations of the powers of the officers of the company. The issue of exceeding the actual authority is now regulated by the first company law directive. Now it's, this directive is recodified into the general company law directive. And we have Article 33A2 stating that restrictions on the powers of the company's officers from the memorandum and articles of association or from the decision of the directors or from a general meeting of the company may not be opposed against third parties, even if they have been published. First of all, Article 33A, paragraph 1 that we discussed before, talks about ultra vires, limits set by objects. And Article 33, paragraph 2 that we are going to discuss now, talks about limitations regarding the powers of the corporate officers. Article 33, both Article 33A2 and the indoor management rule in Royal British Bank versus Tergat abolish constructive notice of public company documents, and their application has broadly the same effect, namely binding the company vis-à-vis a third party that is dealing with the company. But despite whatever they may have in common, Article 33A2 largely replaces the internal management rule in Royal British Bank versus Tergat. For example, various internal irregularities can be interpreted as placing limitations on the powers of the board or others. Now, the indoor management rule and its exceptions continue to apply despite the new provision introduced on the basis of harmonization. The indoor management rule and its exceptions are not entirely superseded. There may be a demarcation where Article 33A applies and where, where the internal management applies. Bearing in mind that this is a scope of Article 33A, the following distinction could be made as to the scope of Article 33A2 and the internal management rule. Article 33A2 will be applied exclusively in cases of restrictions on the powers of the company's officers, for example, cases of excess of power of attorney, but will not be applied in cases of incorrect appointment or lack of quorum, essentially cases of formal invalidity of the decision to which internal management rule could continue to apply. So let's move a little bit. Article 33A2 deals only with limitations to the powers of directors, and it may be argued that some of the cases covered by the indoor management rule extend beyond the scope of Article 33A and goes into the board composition. For example, incorrect appointment, invalid appointment, or some other issues regarding the quorum, decision taken without quorum, all these things. And moreover, the scope of Article 33A is specific and therefore limited. Article 33A2 applies to the officers of the company, the directors, but the indoor management rule applies also to other persons, such as the employees of the company and other persons appointed as agents of the company. So we see that partly some issues are partly regulated by the indoor management rule, and some others are regulated by the new provision on the basis of harmonization. Both regimes continue to apply. And some conclusions. The implementation of EU directives into Cyprus company law do not abolish completely the English common law rules on ultra-vires transactions and restrictions on officers' powers. Someone would expect this on the basis of the constitutional principle of the supremacy of EU law, but this is absolutely compatible with the principle of supremacy because some parts are regulated by the directive and some others, which are not regulated by the directive, are regulated by the common law regime. Some parts of these areas are regulated by the new rules implementing EU directives, and some others areas are still regulated by English common law as it was interpreted by Cyprus courts. A careful delineation is necessary The scope of both regimes must be delineated very carefully. This results in a subtle balance between the implementation of EU harmonization and English common law in the context of Cyprus company law. This issue presents a great interest after Brexit. UK will not implement any other EU company law directives. So Cyprus, Ireland, Malta are now the only EU jurisdictions with a company law system affected by English common law. And I think in future, the developments in this area will be particularly interesting. Of course, not only this area, but generally for other directives being implemented by these jurisdictions with an influence from English common law. Thank you so much. I hope I didn't abuse the time.